SJC-13166, Dhananjay, Patel, and others v. 7-Eleven, Inc. and others.
Hi, Attorney Liz Reardon.
Yes, good morning, Your Honors. May it please the Court, I'm Shannon Liz Reardon. I represent the plaintiffs in this case. What the defendant 7-Eleven is trying to do here is they are asking you to upend 15 years of SJC precedent, which has repeatedly recognized that individuals classified as franchisees may actually be employees under Massachusetts wage laws.
Well, if it's so clear, why is this a certified question?
Well, that's a good question.
I presume the judges on the First Circuit are smart. And if there's 15 years of established SJC precedent, as you just said, why did they certify this to us?
Well, I'll explain that, because the exact argument that 7-Eleven has made here, that there's a conflict between 148B and the franchise rule, has not been specifically addressed in the written opinions of the SJC. But if you look at arguments that have been made to the SJC, which we cited to you in our briefing, this argument has been made in the past and was not adopted by the SJC. So both in the Coverall 2006 unemployment case and the Depianti case, the argument was made that this ABC test simply can't apply to franchisees, and they cited the franchise rule too, but the SJC itself didn't talk about the franchise rule in either of those cases and went off on other grounds. So I think that's why the First Circuit decided it should be addressed and talked about in an actual decision, but the argument itself has been rejected. And the consequences are vast. If 7-Eleven gets its way here and allows the classification of workers as franchisees to be an end run around the wage laws, every industry in the Commonwealth is going to start renaming their employees franchisees. And we've already seen this happening in a number of industries. We're seeing it happening with trucking companies, shuttle services, gas station employees, and even Uber and Lyft, who have been challenged multiple times in multiple places for misclassifying their drivers as independent contractors, have talked about using a, quote, franchisee model so that they can continue avoiding.
I get a little nervous sometimes when both sides say, if you rule the other way, the sky is absolutely going to fall down.
Yes, so actually the franchise industry, the International Franchise Association, represented by Mr. Leone here, has repeatedly said in cases both to this court and other appellate courts around the country that the sky is going to fall if the regular test for distinguishing employees from independent contractors is applied to franchisees. That has been rejected in California, in Pennsylvania, in Connecticut, in Mississippi, and the sky hasn't fallen, and the franchise industry has continued to thrive in Massachusetts even since 2006, that first decision where a franchisee was held by the SJC to be an employee under a modified ABC test and under the unemployment statute. And interestingly, the company that was the defendant in two of the cases that's been before this court, Coverall North America, was ruled years ago to have been misclassifying cleaning workers as franchisees. And as defendant has explained in a letter to you, and as we cited in our reply brief, Coverall is still operating in Massachusetts, but apparently it's operating with employees, having its cleaning workers be employees, which is exactly the right answer here, because these companies...
Can I cut you off for 1 second? So I agree with you that this is kind of oversimplified to take them out of, just because it's a franchise agreement, you can't apply the ABC. But I don't understand how the ABC test is going to apply here. Let me give you a hypothetical. I'm a franchisee, and I'm not a little ma and pa franchisee. I own 12 Dunkin' Donuts franchises. Am I an employee? Because it seems kind of silly. It seems complicated. I understand the people working in the Dunkin' Donuts store they're employed by somebody. They probably are employed by the franchisee. I find that the easy part is what you're fighting over. The harder part is what are we going to do? How is it going to work in this world?
Well, I can tell you exactly how it's going to work. And the ABC test is flexible enough so that we are not saying that all franchisees are employees if you apply the ABC test. So a couple things. First of all, as the FTC has said in its amicus
So
brief here.
take my hypothetical.
Yeah, yes, I will. So for those Dunkin' Donuts employees, you look at the prongs A, B, and C, right? On the control issue, there are franchisors who only exert a certain amount of control. They provide the trademark, they say what products to offer. They give basic operational assistance. They don't give detailed control over what actually happens into the store, such that they are the ones under prong B who are actually running the business. Now, 7-Eleven is unlike traditional franchisors. So 7-Eleven goes much further than what I just stated. 7-Eleven is so involved in the business of the stores that our argument, and this isn't before you, but just to illustrate for you,
Okay, but
our
but
argument is
let
that
me-
7-Eleven
again-
itself is
again,
running the business.
I'd like you to try to deal, and also you're talking very close to the microphone, so you're creating an echo.
Sorry about that.
But I'm just trying to understand how it's going to work, because it seems like there's like, last month, one of your colleagues argued the joint employer issue, which we haven't resolved it. But it seems like we've got joint employer issues and other things. It's just, this is much more complicated than an all or nothing rule. And I'm just, again, I own 10 7-Elevens. And I don't work in any of those stores, but they have all kinds of rules about, am I an employee when I own 10 of those 7-Eleven stores?
Well,
Franchises?
it depends on the facts, and it depends on
Even though
how
I
the
don't work at
ABC
all?
test.
Even though I don't work at all in the stores?
Well, so a couple of things. For one thing, I mean, that may be a factor that the court or a jury looks at in determining the ABC factors. The ABC factors are flexible enough so that they can be applied to the situations. The question is, under prong A, how much control is the franchisor or alleged employer actually exerting over you? So are you running your own independent business, or is it really that you're working as a manager for this company that in truth is really running the business? So that's why prong A and prong B do sometimes sort of seep into each other. I mean, they're independent prongs, but prong A looks at how much control, and like I just said, a lot of franchisors do not exert the level of control that 7-Eleven does, and that's what we would go back and argue at the district court. Under prong B, the question is who is, what is the business? Are the alleged employee and alleged employer actually in the same business or a different business? And I think that turns a lot on whether the franchisor is actually running the stores. So here, what we have in our record is that 7-Eleven doesn't just provide operational business advice. It controls the flow of money. I'm trying to stand back now.
Is your microphone against the thing? It may be
Let's try that.
reverberating.
Is that better? Okay. 7-Eleven controls the bank accounts that the customer revenue goes into. So a typical franchisor gives this operational advice and...
Counsel, I'm sorry to interrupt, but
Yes.
for Justice Kafker's hypothetical,
Yes.
is that franchisee providing services? That is the gating issue of the ABC test. You seem to answer his question by going right into the three prongs. And I'm asking you, is that franchisee providing services?
Yeah, well, yes. I mean, that will be a fact question in each case, but yes, the franchisee, the way 7-Eleven is set up...
No. In the sort of Dunkin' Donuts hypothetical.
Well, I don't know the facts of Dunkin' Donuts
No,
because we
and
don't
I
have that
don't
record here.
either, but as I understand the hypothetical, I am Dunkin' Donuts corporate, and I have a franchisee that, let's say, is Kafker LLC, and and then Kafker hires all these employees to work at the particular Dunkin' Donuts. Let's say there are 10 of them. Is Kafker LLC providing a service?
I mean, it may be. It's really a managerial service. So in the coverall cases...
Dunkin' Donuts corporate?
Excuse me, yeah, it could be. Again, I don't know the facts of Dunkin' Donuts, but if I can
No,
just
it's just
explain.
in this hypothetical, we could call it, let's just not call it Dunkin' Donuts, let's call it Wendland LLC.
Well, I'd like to call it Coverall, because that was a company that was before this court twice. So one of the arguments that Coverall made repeatedly was that its franchisees had a whole lot of employees. That argument was specifically made and rejected. The federal court still held that the ABC test applied, and
Although,
essentially the franchisees
again,
were
but
acting
at
as
Coverall-
managers.
But Coverall, they were really sort of individual janitors.
Some of them were,
They're
and a
not-
lot of
and
them
again-
had extensive franchises with a whole host of people working under them. And Coverall argued, oh, those franchisees can't be employees. Look, they themselves have employees. But actually, these franchisees were effectively working as managers for Coverall. So in other words, 7-Eleven franchisees or Dunkin' Donuts franchisees perhaps may very well be working as managers. And in fact, here, 7-Eleven has corporate-owned stores.
The managers tend not to have, profits. They don't, managers, they get bonuses, but they have employment relationships. This is different because there's a business being run here. I understand, and I'm very sympathetic to the little guy who's working in all these stores. That's an employee. That's why I find this global argument very troubling, that they're all taken out, because that just seems wrong. But I also have very little sympathy for your argument if we're converting entrepreneurs into employees, particularly when we're talking about people who own multiple franchises.
Okay, well, so first of all, there are fact-based questions in here that would go back to the district court to be determined. But secondly, a number of these franchisees are they don't have multiple stores. Some of the named plaintiffs here do, but most of 7-Eleven franchisees
So
have
let's
one
take one of the
store.
ones, let's do an actual one. Give us the one who has the most stores. Tell us about that person.
There are some franchisees who have multiple stores, and they are essentially running around managing the stores. They have employees who work at the stores. They're getting daily emails from 7-Eleven that goes to a 7-Eleven email address telling them what they should do, what items they should take off the shelf, what they should put on the shelf, all these new promotions and policies that they need to implement.
Do they tell the person who to hire and how many hours they should work and control their paycheck? Or does the actual franchisee operate as the employer in those cases?
So a couple of things. One way that employers are trying to get out of claiming that their workers are their employees is by saying that they're not controlling their hours. That is not, under the ABC test, that is not an indication of whether someone is an employee or not. There are plenty of employees who can work whatever hours they want. What you see in these situations with both franchisors and it is kind of similar to the joint employment issue that you heard about in the Credico case, which is that employers are figuring out so many ways to do an end run around the wage laws, and they're setting up what David Weil calls these fissured workplace schedules, systems that includes joint employment issues as well as franchise arrangements to make it look like the big employer on top, who really is running the show, is not responsible for complying with the wage laws for the franchisees or the people who are under them. Those are related issues. But I also I could go on and on about how this fits with your hypothetical, Justice Kofker, but I want to emphasize what I was trying to say before. 7-Eleven is different from most franchisors. Most franchisors take something like a 4 to 7% fee in exchange for giving this operational support. 7-Eleven not only controls the bank accounts, but it takes half of the revenue. It's designated half of the revenue as the franchisees and half as its own, and then has the franchisees pay for all of the operations of the store.
Counsel,
but it could be.
let you finish your sentence.
Yeah, yes. You can have a very similar arrangement where the employee is being paid based on how well the business profits.
Okay.
That happens all the time in employment relationships, but here, the mere fact that their pay depends on how well the store is doing, that could be, that's how employment
I think we understand
payment
that,
systems.
and I don't want to oversimplify Justice Kafker's question.
Yes.
But my understanding of what we're answering here today is whether this statute can be applied, not whether it will be applied. Is that correct?
Yeah,
And
exactly.
that will depend heavily on the facts and circumstances of each case, whether it applies.
Correct. What 711 is asking for is just a global carve-out, which is a legislative choice which has not been made by our legislature. In fact, the International Franchise Association, which Mr. Leon was involved in, tried to get that carve-out from the legislature, and the legislature didn't do it. They're also trying to do it in California. California legislature said no. The Ninth Circuit said in Vasquez versus Janpro, no, there's no exception in our state law for franchises. Apply the ABC test to a franchise situation. Even in 711, the Ninth Circuit, in the case of Haitayan versus 711, reversed a dismissal of a misclassification claim and remanded for consideration now that California had adopted Massachusetts' ABC test. It went back for trial. The court didn't apply the ABC test. The case is back on appeal. But the point is that the Ninth Circuit also agreed specifically with respect to 711, we have an ABC test. Go apply it. So 711 is asking this court to make a legislative choice the legislature has not chosen to do. It will not end franchising in Massachusetts, as it hasn't for the last 16 years. Should the ABC test be applied here? Massachusetts has the strongest.
Sorry, we're at the end of your time, and so I thank you, and we're going to hear from Attorney Leon at this time.
Thank you, Your Honors.
Thank you.
Good morning. May it please the court. Your Honors, before addressing counsel's comments, there were two quick points I wanted to make to try to frame the issue before the court and to hopefully explain why we believe that the answer to the certified question needs to be no. The first is that no one, not the plaintiffs, not the FTC or the AG, has explained how it is possible for any franchisor to pass the ABC test.
Can I ask you a question, counsel? If we adopted your position, would we be overruling the two, I forget, the Coverall case and the Monell case? Would those be overruled?
No, not at all, Your Honor.
Why not?
No decision from this court has ever specifically addressed the application of the ABC test to franchise businesses. I know that the plaintiffs and their amici take that position, but if you look at the cases, they're quite clear that they didn't address it. The closest this court ever came was in De Pianti, where it addressed the implications of the Lanham Act and how that impacted franchise businesses. But this court actually made clear there in footnote 14 that, quote, we neither analyze the elements necessary to maintain a claim under GL Chapter 149, Section 148B, nor consider the application of the statute to franchise arrangements such as the one here. So there is no guiding law on that, which is precisely why the First Circuit certified the question to this court. The second point I wanted to make was that no one, not the plaintiffs, not the FTC, not the AG, has explained how any franchisor doing business in Massachusetts can stay in business if they're deemed an employer, because under governing law, under AWUA and Sebago, the franchise fees, both the initial and ongoing fees that franchisors depend on, and that the Commonwealth taxes, are against public policy and void. The record here is undisputed and clear that that is 100% of the revenue that franchisors
Isn't that
rely on.
about applying the test, not about whether the test should be applied? Isn't that, I mean, isn't the argument you're making that 7-Eleven should not be found to be an employer? That doesn't really answer the question as to whether or not we should be applying the test at all.
I think, Your Honor, the fact that no franchisor can pass the test and that no franchisor can exist financially if the test applies underscores and proves conclusively why the test cannot be applied to franchise businesses. There may be another test.
That can't be right, because we've already had the Georgia Court of Appeals say that you can survive the test, applying Massachusetts law, right? So somebody survived it.
That's actually incorrect, Your Honor. I know that's the position that the plaintiffs take, but the Georgia Court of Appeals decision involving the Janpro case, 2011 court decision, that court determined that Janpro passed the test only because the Janpro system was devised as a three-tier system. They held that there was no control and that the franchisee was in a different course of business than the franchisor, because the only direct commercial relationship that existed in that case was the one between the franchisee and the master franchisee. There was no relationship at all between Janpro and the franchisee who claimed they had been misclassified. This court rejected that very reasoning 2 years later in the De Pianti case, when it ruled that no direct relationship was required to sustain a claim under the Wage Act.
Yeah, I've read the case, I don't read it your way, but I don't want to debate that. But how about the fact that the FTC, I take it the First Circuit didn't have the benefit of the FTC's own interpretation of this rule, right?
There was no brief filed by the FTC before the First Circuit, but I don't believe that its view impacts the question before the court for a couple of reasons.
They're saying it's a disclosure rule, and that's all it is, and they're saying it doesn't interfere with the ABC rule. Can I ask more particularly, take my hypothetical, because I'm worried about all the employees of these places. I'm not worried about the guy who owns 10 stores. I'm worried about all those people working, there. And, again, we're not just talking about the 7-Eleven store where the franchisee is sitting in the store 24 hours a day. We're talking about all of these relationships. If we adopt your rule, right, every franchisor is outside of the Wage Act, and all the people who work in these places is outside of it, right?
No, not at all, Your Honor.
Tell
The
me
only
how-
people,
How is that, explain that.
the only people that we're talking about today are the ones that you discussed in your hypothetical, the people that own the franchises, the person that owns the 12 Dunkin' Donuts or the 6 7-Elevens. This has nothing to do with the people that work for them, and I think that's an
So
important...
how are they protected? If this is a true franchise arrangement and they're employees in these places, how are they protected under the wage laws? That's where I'm confused by.
The employees of the franchisees themselves, of course, still have the protections of the wage laws. The franchisees themselves, our point, should not have the protections of the wage laws because they can't be employees. The test that applies necessarily renders
Anyone who works for the franchisee is covered, but the people who are the franchisees are not?
Absolutely.
That's not that clear from your briefing.
And I apologize if we didn't make that clear, Your Honor, but that's the point that we're pressing here, and I think it's an important one to emphasize because this case is not about store clerks being deprived the minimum wage or deprived breaks or anything like that, anything but it. These plaintiffs are wealthy individuals that own multiple businesses and have many employees of their own right. What this case is about is an attempt to use the Wage Act to have those business owners receive back from 7-Eleven, threefold, of course, as required under the Wage Act, all of the expenses that they incurred operating their businesses, including the hundreds of thousands of dollars they pay every single year to their own employees. That's what they're seeking in this case, the payroll that these business owners paid to their own employees as damages. The Wage Act was never intended to
Can you
produce such an
answer-
absurd result.
So Justice Cypher's question, the one that all this is about whether this act applies. What is your response to her point, given what you just said there?
I think the response is that there is no franchisor who has ever passed this test. There is no franchisor that can pass this test. Every single relationship, every single franchise relationship under law, as defined by the FTC rule and by necessity, contains control as a required element of that relationship. This court recognized that in the De Pianti case, when it held specifically that under the Lanham Act...
Then why aren't you joint employers of, if that's the case, if you need that much control to be a franchisor, why aren't you joint employers of all of these employees that you say are covered?
None of these employees are involved in this case, Your Honor. Again, we're just talking about the franchisees.
We gotta, you're asking for a blanket rule that all franchisees are not employees because of the control required in the franchisor rule. And I'm trying to understand how this is gonna work in the real world, because you're saying we're gonna blow up all these franchise arrangements, but you're also saying the employees are protected. But if this franchisee is being dictated by the franchisor how they run their employment relationships, we're running into joint employment issues.
Well, the cases that have come out addressing the joint employment issue in franchise cases, Your Honor, have uniformly held that the controls that franchisors need to exercise to protect their brand and their marks and their system are not indicia of a joint employment relationship. Every case that has reached a merits determination on that has held that.
Which
And
cases are those? Could you have them handy, or are they in your brief somewhere?
The Salazar versus McDonald's case from the Ninth Circuit is in our brief, Your Honor, and I'd also cite for you as examples because they collect a lot of cases. The In Domino's Pizza case, which is 2018 Westlaw 4757944, and In Jimmy John's overtime litigation, which is 2018 Westlaw 3231273. So the underlying issue here is that franchising is not some scheme that has been developed to evade the Wage Act. That's not how it came about. It's been in existence for over 100 years. 7-Eleven has been involved in franchising for over 50 years, and the relationship between these parties is one that is entirely legal and is entirely compliant with the detailed statutory scheme that has put in place to regulate the sale of franchises. Nobody disputes that. The problem with applying the ABC test is that it renders every franchisor an employer simply because they complied with what that regulatory scheme details.
I'm just not sure of that the control means exactly the same thing, devoid of any factual predicate. The ABC test talks about control over the method of performance of service. And when you look at the definition of a franchise, it's the control over the franchisee's method of operation. And I'm not really sure those are exactly the same thing, devoid of any facts. And I think that's sort of, as Chief Justice Budd and Justice Cipher were referencing. This is just to say whether, in a certain circumstance, the independent contractor law, whether it's going to apply, what the result of this case would be would require some factual development, wouldn't it?
No, I don't believe it does, Your Honor.
So you say, and I know, your position is, by definition, the ABC test captures every franchisee relationship, period, end of story.
Yes, Your Honor. And if it did not, then the plaintiffs surely would have been able to give this court one example where it would not capture a franchisee, but they haven't because they can't. None exist. The problem here is really twofold. As I mentioned, just going back to this court's holding in De Pianti, you start out first with a requirement that every franchise have a license to use the franchisor's mark. Under the Lanham Act, 15 U.S.C. 1064 sub 5 and 15 U.S.C. 1127, a licensor of a mark, and every franchisor is a licensor of a mark. It's part of the FTC rule. Every licensor must exercise control over the quality and nature of the goods that a licensee produces under the licensor's marks. That alone imposes an obligation on every franchisor to make sure that the franchisees are producing products that are of a certain standard. It's not just there to protect the mark owner. It's there to protect consumer expectations. That's the whole purpose of the Lanham Act.
But is that franchisee using the mark, are they providing services, going back to my question to your opposing counsel?
The district court held, Your Honor, that that was a question of fact, and I think that the district court got it wrong on that because the only assertion that the plaintiffs have made here about why they provide services to 7-Eleven is that they operated a 7-Eleven store and paid the equivalent of royalties to 7-Eleven. If that's the standard, then of course every franchisor is in fact the presumptive employer of all of its franchisees. Not just that, I would say that every copyright licensor and every trademark licensor.
Right, and so if we decide that that is wrong, then isn't that the answer to the question that you find so puzzling?
I think
that
that'll.
in fact you can be a franchisor and still be subject to the ABC test if your franchisee is providing services?
If the operation of a franchise location and the compliance with the obligations under a franchise agreement do not equate to providing services, then the conflict with the ABC rule obviously does not come into place because you never get to the ABC test.
Exactly.
Yes, I would agree with that, Your Honor.
Okay.
Now, I did want to address for a few minutes some of the positions that the AG takes in her brief. And I would submit with respect that the AG's position in this case is not entitled to deference for a couple of reasons. First of all, the AG's view as to what tests should apply to franchise businesses is premised on her belief as to what federal laws and regulations mean. And it's well-settled law that on matters of federal law and regulation over which the AG has no control and which she does not administer, her views are not entitled to deference. And I'd cite, for your honors, the rights.
Aren't her views consistent with the general counsel or the acting general counsel of the FTC's views?
I don't think that the FTC's views have anything to do with the arguments that we're presenting to this court. And I think it's important, Your Honor, to understand what the FTC rule and what the FTC rule is and what it is not. The FTC rule is, as the FTC points out, just a disclosure regime. We've never contended otherwise. And we don't contend that there is anything in the ICL that prevents a franchisor from issuing the disclosures that the FTC rule requires. So the FTC rule controls the relationship, what a franchisor needs to do to sell a franchise, up until the time that a franchise agreement is signed. At that point, the FTC has no further relationship, nothing to do with how a franchisor and a franchisee interact with each other. So if you view the rule in that context, the FTC is correct that there is not some free-floating obligation for a franchisor to exercise control over its franchisees. However, the thing that franchisors are allowed to sell by complying with the rule, the franchise, is defined by the same FTC as a commercial relationship in which the franchisor exerts or has the authority to exert a significant degree of control over the franchisee's operations. That's exactly what the district court held here. So if that's not a conflict, I don't know what is, because I could issue the disclosures, but to what end? I can't sell what the disclosures are designed to sell. And if the FTC is taking the position, frankly, that a franchise means something other than a commercial relationship in which the franchisor has to exert control, then its views are directly contrary to the plain meaning of the regulation it's charged with enforcing, and I would say they should be disregarded and are entitled to no deference. I see my time is up.
Okay, thank you.